Welcome to our monthly commercial bulletin, brought to you in association with LexisNexis and Radius Law. This month we're introducing a new, snappier format as we understand your time is precious. Our video will include the key stories of the month, and you'll be able to access more background information on the stories in our News In document, along with our glossary of terms and links through to further recommended reading in Lexis PSL. The recent Wells v Devani case concerned an estate agent's claim for commission. The Court of Appeal, overturning the High Court decision, said that because the trigger for commission had not been agreed, there was no contract. The Court of Appeal dismissed the High Court's opinion that this detail could be implied in the contract, as this would be putting the cart before the horse. There must be a contract before you can consider implying terms into it. 4MLD will be implemented in 2017 and will make numerous changes to existing anti-money laundering laws, particularly the requirement to have beneficial ownership of companies reported in real time rather than annually. BEIS is seeking views on the implementation of 4MLD. You have until the 16th of December to have your say. It's a common problem. A tenant wants to assign a lease. The lease says that the assignment is subject to consent not to be unreasonably withheld. But the parties have a difference of opinion on what's reasonable and how quickly it should all happen. It's often forgotten, however, that the Landlord and Tenant Act of 1988 also places a statutory duty and the onus of proof on the landlord to be reasonable. In the recent case of West India Quay, the East Tower Apartments, the landlord required a bank reference, a survey and an undertaking for its costs of £1,600. The tenant said it was unreasonable and that the landlord was too slow. The High Court determined that the delay was not unreasonable. The clock only started to tick when the application was served on the correct address, and the landlord had dealt with it within 14 days. The conditions of a survey and a bank reference were reasonable, but unfortunately for the landlord, the undertaking for costs was not. In the recent Court of Appeal decision, the claimant successfully argued that the defendant was not entitled to end the contract based on the common law doctrine of frustration. The defendant claimed that the contract with the claimant was frustrated because the contracted services relating to the management of third parties had already been terminated. The Court of Appeal, however, determined that frustration did not apply here because the description of the contracted services was wider than the defendant had stated. The defendant had delayed the termination, and for frustration to apply, the frustrating event must be an outside event that's not foreseeable. The UK government has confirmed that regardless of Brexit, it will be implementing the GDPR by the 25th of May 2018. The ICO has published guidance on GDPR preparation, together with priorities and an overview. As we've previously predicted, two challenges have now been lodged in the European Court to annul the EU-US Privacy Shield. We're not yet sure how long these proceedings will take, but we'll keep watching this space and bring you further updates in the new year. In the case of McWilliams v Citibank, an employee who had been dismissed made a subject access request, a SAR, for information relating to her, which was refused. The Employment Tribunal determined that even if the SAR was disproportionate, the employer must still supply documents on a more limited or proportionate basis rather than an outright refusal. This is a good reminder that employers should not use technical legal rules in employment cases, but must stand back and consider what's reasonable. The Employment Tribunal case of Aslam and others v Uber has been the big employment law story in the last few weeks. This is one of the first of the so-called gig economy cases to come to a tribunal. The claimants successfully argued that they were workers and therefore entitled to paid holiday and the minimum wage. The tribunal dismissed Uber's arguments that the claimants were self-employed as nonsense. The claimants are paid by Uber, not the passenger, and not permitted to have the contact details of the passengers, not allowed to substitute themselves for another driver, and Uber performance manage them. These are all factors that point towards a worker status rather than being self-employed. It has always been clear that the Trademarks Act of 1994, the TMA, has criminalised the sale of counterfeit goods. However, a recent decision has confirmed that the TMA also criminalises the sale of grey goods. Grey goods are goods that are genuine goods, but the sale has not been authorised by the brand owner. Typically, this relates to the unauthorised sales of goods within the EU, provided the brand owner has not already placed the goods for sale in the EU. This is good news for brand owners as it provides another weapon for their fight against infringements. It's unlikely, however, that Trade and Standards will take enforcement action, so brand owners will need to use private prosecutions. The Consumer Rights Act, implemented in 2015, outlaws unfair terms in consumer contracts. However, research by the CMA has identified that more than half of businesses are unsure of the law on unfair contract terms. To address this lack of awareness, the CMA has written a blog and has produced explanatory videos. The CMA has also taken action to enforce the fairness rules and in November secured commitments from 4 cloud storage providers to implement fairer terms to their customers. The changes include ensuring customers have clear information on how to cancel contracts if they do not want to accept changes to the current terms. We have previously reported on proposals by the European Commission to ban traders from discriminating against customers located in other EU member states. This is typically done by redirecting customers to websites depending on where they are located, a practice known as geo-blocking. A draft regulation has been published that will be directly applicable to UK businesses and is expected to be enforced by mid-2017. We'll keep watching this space and bring you more developments in future bulletins. You can now click on the News In link to read all the background information on these stories. Join us again in January for a look ahead to 2017.